Imagine stepping into a courtroom where logic bends, the truth hides behind laughter, and justice wears a crooked smile. Today's case is not just a trial, it's a journey into the heart of a controversy so bizarre it could only happen in real life. We are about to explore the story of a woman who sparked a heated debate about something as fundamental as our own genetic makeup, DNA. In 2003, a woman named Anya lifted the veil on a claim that would send ripples through the scientific and legal communities. She asserted that she had copyrighted her DNA. Yes, you heard that right. A claim that seems to challenge the very notion of ownership and raises questions about the ethical implications of genetic material. Anya, a woman with a background in biotechnology, was no stranger to the complexities of genetics. But what led her to take this bold step? Was it a quest for personal empowerment, a financial opportunity, or a misunderstanding of intellectual property law? To understand her motivations, we need to dig deeper into the context surrounding her claim. The early 2000s were a pivotal time for genetics. The Human Genome Project, completed in 2003, mapped the entire human genome, unveiling the secrets hidden in our DNA. Suddenly, genes were not just scientific curiosities, they were potential gold mines. The commercial interest in genetic material skyrocketed, with biotech companies racing to patent genes and develop treatments based on genetic research. It was within this environment that Anya decided to take a stand. In her mind, her DNA was not just a series of biological codes, it was a unique signature that deserved protection. She framed her decision as a response to a broader issue, the commercialization of genetic material without the consent of the individuals from whom it originated. Anya's claim raised eyebrows across the board. Legal experts were quick to point out the challenges surrounding the concept of copyrighting DNA. Copyright law traditionally protects original works of authorship, such as literature, art, and music. DNA, however, is a natural phenomenon and does not easily fit into these categories. Furthermore, the U.S. Patent and Trademark Office has ruled that genes, as products of nature, cannot be patented. Yet Anya pressed on, arguing that her DNA was a part of her identity and that she had the right to control how it was used, much like an artist controls their work. She envisioned a future where individuals could license their genetic material, earning royalties from companies that sought to use it for research or product development. As Anya's story gained traction, it ignited a flame of discussion across various platforms. Supporters hailed her as a pioneer, a woman standing up against a system that commodified human life. Detractors, however, labeled her an opportunist, suggesting that her claim was not only misguided but could set a dangerous precedent in the realm of genetic research. The courtroom became a battleground for these conflicting views. Legal analysts dissected the implications of her claim, weighing the ethical considerations against the legal framework. Could one truly own a piece of their DNA? What would this mean for medical research and the future of genetics? Some experts argued that if Anya's claim was validated, it would open the floodgates for individuals to assert ownership over their genetic material, leading to a landscape where every person could potentially charge for their DNA. This could create a divide where those with rare genetic traits could profit while others, who might not have unique genes, would be left in the cold. On the other side of the argument, advocates for genetic research warned that such a precedent could hinder scientific progress. If every researcher had to navigate a maze of individual DNA copyrights, it could stifle innovation and slow down life-saving discoveries. The balance between individual rights and the collective good became a central theme in the courtroom discussions. As the case unfolded, it drew attention from media outlets and the public alike. Anya became a controversial figure, a symbol of the ongoing struggle between personal rights and scientific advancement. Her motivations were questioned, her character scrutinized. Was she truly fighting for a noble cause, or was she simply seeking fame and fortune? The hearings were filled with passionate testimonies. Anya spoke candidly about her experiences. She shared stories of family members who suffered from genetic disorders, emphasizing the importance of understanding one's genetic makeup. She argued that individuals should have the right to decide how their genetic information is used, particularly in an age where data privacy is increasingly at risk. In response, legal experts presented counterarguments. They highlighted the established principles of genetic research, detailing how the scientific community has thrived on the sharing of knowledge and collaboration. They argued that Anya's claims could disrupt the very foundation of medical research, where collective data is crucial for advancements in understanding diseases and developing treatments. The courtroom atmosphere was charged, with spectators divided. Some cheered for Anya, brandishing signs that read "My DNA, my rights," while others wore shirts proclaiming science over selfishness. It was a spectacle that transcended the legalities of the case and tapped into deeper societal issues of identity, ownership, and the ethical landscape of genetic research. In the midst of this chaos, a pivotal moment occurred. A prominent geneticist took the stand, asserting that while Anya's desire for autonomy over her genetic material was commendable, the implications of her claim could lead to a slippery slope. If individual ownership became the norm, it could create a fragmented approach to genetics, where people could withhold their DNA for personal gain, ultimately hampering the progress of medical research and public health initiatives. As days turned into weeks, the case garnered international attention. Discussions about the ethics of genetic ownership spilled into forums, blogs, and news articles. People began to reflect on their own relationship with their genes. What does it mean to own a part of oneself? In a world where genetic testing is becoming commonplace, how much control should individuals have over their genetic data? Amidst all the noise, Anya remained steadfast. She maintained that her claim was about empowerment and education. She envisioned a world where people were not just passive subjects of genetic research, but active participants in the narrative surrounding their own DNA. As the trial reached its climax, the courtroom buzzed with anticipation. The judge's decision would not only impact Anya's life, but could also reshape the landscape of genetic ownership. Would the verdict support Anya's groundbreaking claim, or would it affirm the established norms of genetic research? Finally, the day of reckoning arrived. As the judge delivered the verdict, the air was thick with tension. The ruling was a nuanced one, neither fully endorsing Anya's claim nor outright dismissing it. The judge recognized the validity of the ethical concerns raised by Anya, but ultimately sided with the scientific community, stating that while individuals have rights over their genetic material, the complexities of ownership in the realm of science require a more collaborative approach. While Anya did not achieve the complete validation of her claim, the case opened the door to important discussions about genetic rights and ownership. It revealed the profound implications of what it means to share our genetic material and how it is used by others. In the aftermath of the trial, Anya became an advocate for genetic literacy, using her experience to educate others about the importance of understanding one's own DNA. She emphasized the need for a legal framework that respects individual rights while promoting the collective good of scientific progress. So what can we learn from Anya's journey? The case of copywriting DNA highlights the intersection of ethics, law, and science in an era where our genetic information is more accessible than ever. It beckons us to reconsider our notions of ownership and identity in a world where the lines between the personal and the commercial are increasingly blurred. As we reflect on this story, it is clear that the quest for understanding our own genetic makeup is fraught with complexities. Anya's claim may not have rewritten the legal landscape, but it certainly sparked a conversation that will continue to evolve as we navigate the ever-changing terrain of genetics and ownership. In this courtroom, where reality is indeed stranger than fiction, we are reminded that the quest for knowledge and understanding is a journey worth taking, even when the path is riddled with controversy.